Good morning, Counsel.
Good morning, Your Honors. May it please the Court, my name is Mario Giamoni and I represent the appellant Hempstead Marine. Your Honors, our position on appeal with respect to the directed verdict.
Before you get rolling, do you want to save some time for about?
I'd like 2 minutes for both.
Sure.
Thank you. Our position on appeal with respect to the directed verdict issue, Your Honor, is that R&I Shipping failed to present any evidence whatsoever establishing the existence of an oral contract to pull the vessel out of the Miami River on Friday, January 23rd, 2000.
Well, you go as far as saying there was an agreement and a course of conduct to tow the vessel out of the river sometime between January 21st and 24th.
So, Your Honor, there was absolutely an agreement to tow the vessel on the 21st. On the 21st, the crewman was injured. Without the engineer, the ship was not allowed to leave port.
So, well, let's take it piece by piece. So there's an agreement, there's an oral agreement.
Yes.
And so what's in contention is, was it the 23rd or was it the 24th?
Right, and this is very important, Your Honor, because...
Yes, because of the arrest.
Because of the arrest and because the specific claim by R&I Shipping, they sued Hempstead Marine specifically alleging that the 23rd was the day that the boat was supposed to leave port, and that was the agreement.
Okay, understood. Now we're between the 23rd and the 24th. Is there disputed testimony among the three people who were involved in that decision?
Your Honor, the testimony of...
Well, let's have a yes or no first, and then we'll...
There's disputed testimony as to whether there was a contract for the 24th, whether there's a contract for the 23rd. However, there was no evidence presented by Mr. Gonzalez that in fact a contract for the 23rd existed. He admitted that he left all contracting matters for towing to his authorized agent and partner in this voyage to Haiti. He left all matters to him. So if Your Honor is asking whether there's a dispute between Mr. Dubin...
Oh, so Mr. Dubin.
Yes.
So your argument is that Dubin was responsible for pinning down the date and never said the 23rd.
And in fact said the 24th. And when you look at Mr. Gonzalez's testimony on direct examination, which was his own, that was the only witness for R&I Shipping, he never said that there was a contract for the 23rd. What is required in an oral agreement, Your Honor, is obviously a conversation.
Did he say that he came to the dock and was shocked that on the 23rd and was shocked to see that the vessel was still there?
He did.
Does that suggest that he wanted the vessel out of there on the 23rd?
It suggests that he wanted it out. However, there was no evidence that that was the agreement. He left that up to Dubin. And in fact, what Mr. Gonzalez says is, I get to the docks, I see that my boat is still there, and a day before that, what he says on page, I believe, Your Honor, 101 of the transcript, he says, I was even looking for other tug companies to tow my vessel. That was before the 23rd. So, to your point, Your Salter, that there was an expectation that the boat was supposed to get towed on the 23rd, it vacillated between the 22nd, 23rd, and he admitted that he left all contracting matters to Dubin.
Now, did Dubin ever express uncertainty and say, I can't recall?
Absolutely not. Dubin said the contract was for the 24th. That is what he spoke to Mr. Hempstead for. Mr. Hempstead testified that on the 24th, he got a call from the U.S. Marshal's office. The U.S. Marshal's office knew to contact him because of pilot schedule. There's a pilot schedule, excuse me. There's a pilot schedule for all the boats that are going to go out. The U.S. Marshals knew to call Mr. Hempstead on the 24th because the boat was supposed to leave and set sail at 1100 hours on the 24th. So if you look, and since this is directed verdict, Your Honor, if you look just at the testimony by Mr. Gonzalez, what Mr. Gonzalez never says is, once I found out that the crewman was injured, I immediately got on the phone with Mr. Hempstead from the Marine Towing Company. I called him on this date. He never says what date this took place. He never says who he spoke with. He never says that I told him I need the boat towed on the 23rd, and there was never testimony saying, yes, I agree, the boat will be towed on the 23rd. All the elements necessary to meet their burden, because this is their case, were not present in the record, Your Honor. And because of that, a directed verdict should have been granted in favor of Hempstead Marine. point the court out to another part of the testimony where even though, and they might bring this up, and that's part of transcript 105, page 105, even though Mr. Gonzalez says that Mr. Hempstead acknowledged that there was a contract to tow, we're not disputing that there's a contract. What Mr. Gonzalez failed to say is Mr. Hempstead acknowledged there was a contract on the 23rd. We are saying that that was missing, and because of that, the directed verdict should have been granted in Hempstead Marine's favor. Your Honor, second issue on appeal relates to damages, and that's broken up into two separate arguments. The first argument is regarding improper admission of certain handwritten notes that were used to present evidence of lost profits had the voyage taken place. The second argument relates to the speculative nature of R&S Shipping's lost profits through the testimony of Mr. Gonzalez. I'll start with the hearsay issue first, Your Honor. R&S Shipping proved its lost profits at trial with these handwritten notes that Mr. Gonzalez prepared. There was also a printout of all the expenses that were related to the trip.
Is that competent evidence?
That evidence should have been excluded, Your Honor. There was no testimony whatsoever in the record meeting the requirements of the business record exception under 90.8036. They completely failed to establish that the records were made at or near the time of the event. Without that piece, without that foundational requirement that is supposed to be present when you introduce
Was
these
the
records.
objection sufficiently specific to preserve that?
Absolutely, Your Honor.
Why is that?
The objection, the counsel objected based on hearsay. He objected based
Improper foundation.
an improper foundation. The improper foundation, I agree that that is not enough, but he objected, he made a specific hearsay objection, and he cited the hearsay. The case law is very...
But if the document is admitted as a business record, then that's an exception to the hearsay rule. So hearsay would not be sufficient to alert the court that the issue here is a specific aspect of foundation that the record was not made contemporaneously with the event. Is
Your
that
Honor,
right?
I would disagree that a hearsay, when a party makes a hearsay objection and cites this hearsay rule as the basis for their objection, the case law is very clear that that is sufficient.
With respect to a foundation issue for a business record?
To preserve the objection that the record should not have come in based on hearsay. So our objection was hearsay. They did meet the foundational requirements in order for the record to be admitted under the hearsay rule.
He's the owner of the business, right?
Mr. Hempstead?
Yeah.
Yes.
Okay.
So, Your Honor, going back to your preservation issue, the cases that the appellee cites, Jackson and Montes Belton, I agree that those cases, they were non-specific, non-hearsay objections, and then on appeal, they tried to say that the record should not have come in. The reason why they didn't meet the foundational requirements was because of hearsay. And the court said no, a lack of foundational objection is not enough, and an improper predicate is not enough. The Carter case, Your Honor, from the 4th District in 2007 is very clear that an objection to hearsay is enough to preserve the issue on appeal regarding that the record should not have come in based on the foundational requirements. So going back to the hearsay issue, Your Honor, our position is that the record should not have come in because it didn't meet the requirements of the rule. And because that was the only test, that was the only evidence that Mr. Gonzalez relied on in order to prove his damages, there was no other evidence to prove the lost profits. Therefore, we believe that a new trial on damages is required. Your Honor, the last part of our argument is regarding the damages with regard to lost profits. And our position here is twofold. First, a new trial or remitter should be granted because, and this dovetails into the previous argument, because it was admitted, Mr. Gonzalez admitted on page 160 of the transcript that the only evidence that he had supporting his lost profits had the voyage taken place were based on these handwritten notes that we don't know when they were made. So if the notes are out, Your Honor, we believe that there's insufficient evidence and R&I Shipping failed to prove its damages. That is as to the new trial portion. We also filed a motion for a timely post-trial motion for remittitor, and that was based on the fact that the evidence at trial demonstrated that the lost profits were grossly inflated. Not only were the profits inflated, but the expenses were minimized. Specifically, Mr. Gonzalez has only done one trip like this before. He admitted to that. He didn't introduce any evidence of what the profits were from that other trip, the only trip he's done. He admitted that the lost profits calculations weren't exact and, quote, off the top of your head rate kind of thing. So basically,
This is not Carnival Cruise Lines here. This is a guy running voyages from the Miami River to Haiti with a small vessel. So you wouldn't expect, would you, to see lots of accounting records, lots of...
we're not asking, Your Honor, that our position is not regarding that. What our position is that he speculated as to the amount of expenses that he was going to incur. He minimized certain expenses such as terminal layup fees when we get to Haiti, the unloading and loading of the cargo using cranes. That was not calculated. Customs fees were minimized. In fact, the expense sheet that we believe should not have been admitted said that the expenses were $123,000. Yet when Mr. Gonzalez did his damages calculation, he said, okay, we're going to have $380,000 in lost profits minus $63,000 in expenses versus $183 gives a total of $288, and that's exactly what the jury awarded. So we believe that the only competent evidence establishing profits, lost profits, came from Mr. Dubin. And Mr. Dubin has been doing this for 30 years. In January of 2009 alone, he did 20 trips in a ship very similar. In fact, Mr. Dubin was able to, once the boat was seized by the U.S. Marshals, he was able to take that cargo and he was able to actually do and go to Haiti. And he estimated that the profits, based on all his knowledge and based on the trip that he did just a few weeks later, actually amounted to $20,000 to $30,000. And it was undisputed that the profits would have been split equally between Mr. Gonzalez and Mr. Dubin.
Both these gentlemen testified at trial, correct?
Yes, Your Honor.
They testified to these facts that you stated,
Yes, Your Honor.
and went to the jury.
Yes.
And the jury apparently made a credibility issue finding.
Your Honor,
So what do you want us to do?
we believe that remittitor is required in this case in order for the jury's verdict. The jury's verdict doesn't comport with the evidence that was presented. Worst day possible, Your Honor, it should be the jury's verdict, the judgment should be cut in half to $144,000 because it was undisputed that the profits that Mr. Gonzalez testified to were supposed to be split 50-50. He shouldn't get the whole pie from the trip when there was testimony from him that was going to be split. We believe that the jury got that part wrong.
We've taken you over. If you'd like to make a couple quick points.
Your Honor, based on all the arguments, we believe that the judgment should be vacated and that the judgment should be entered, based on the record verdict, should be entered in favor of Hempstead Marine. We believe that a new trial on damages should be awarded based on the improper admission of those hearsay documents. Alternatively, Your Honor, we believe a remitter should be entered between $15,000, a higher number, that would be proper, $15,000, or alternatively $144,000, because the evidence was clear that it was supposed to be split.
Thank you very much.
Thank you.
We have a couple of minutes.
Thank you.
Counsel.
Wayne Atkins, on behalf of the appellee. I will start with the issue about the existence of a oral contract. I do not believe, although it's presented in the briefs as an issue of whether there's sufficient evidence to support the existence of a contract, the initial brief seems to admit, and the testimony even from appellant's own witnesses seems to say that there was a contract in some form. What this appears to be is actually a dispute over what the terms of that contract was. And I think that's a dispute for the jury to resolve, because otherwise, anytime there was a breach of contract...
So I think his point is that there is absolutely no evidence from the two people having the conversation that the 23rd was to be the date. That's what I'm hearing and reading.
Yes, I believe that is the argument. I believe that's a little different from saying no contract existed, but I do believe there was evidence to support that and it was a conflict for the jury to resolve because Mr. Gonzalez, he testified about how he generally, when they called up these towing companies, it would be the same day or the next day for them to
Let's
tow.
kind of go past that because it's, at least for this judge, you know, that there is an agreement, there's a pattern of conduct and so forth. So let's focus on what evidence is there that the 23rd was the definitive date put into the contract, the oral agreement.
Okay, well, I believe everyone agrees there was an initial agreement to tow on the 21st that was delayed by the injury.
Right.
Then Mr. Gonzalez testified that he made arrangements quickly to replace the engineer who was injured, and that based on the arrangements he made and the past history of conduct, he expected the vessel to be towed the 22nd or no later than the 23rd. When it wasn't towed by
But
the...
he communicates all of that to Dubin, right? Not to the other gentleman, the
Hempstead.
Hempstead.
I believe initially Dubin was handling it. Well, he communicated that to the jury, but initially I believe that would have been Dubin handling it. But there is also testimony that on the 23rd, when it wasn't towed yet, they called up Mr. Hempstead and said, "Why isn't it towed?" And he said, "Because of the arrest, but we know the arrest hadn't happened yet." So I believe that is evidence to support the existence of a contract to tow on the 23rd that a jury was entitled to plead. And then the issue as to the notes. The handwritten notes were admitted as business records, and the objection was lack of predicate, which counsel admitted in itself is insufficient. But there was also a hearsay objection, and I believe in their reply brief they cited to a case Carter v. State from the 4th DCA saying hearsay is generally enough. I don't believe this court has ever held that as a general rule to state your objection with specificity, and I don't believe that case was dealing with a situation like this where it seems to turn on the more technical laying out of the
Carter was
predicate.
about police reports. Carter was about police reports, which is a little bit different, but it did hold that the hearsay objection was sufficient.
It did hold that, but I don't believe it was dealing with...
You would agree that the reason that we keep out hearsay is because it is hearsay and not reliable. But the exception is the business record, correct?
Correct.
So a business record for which a proper foundation hasn't been set or hasn't been laid is hearsay, right?
No, I believe the document either
This
is or
record-
isn't hearsay, regardless
This
of the question.
business record for which a proper foundation has not been laid is hearsay. So in
No,
order to offer it as a business record, you've got to lay a proper foundation, correct?
you generally are required to lay a proper foundation. That doesn't make it, the question you ask doesn't make it hearsay or not hearsay. It either is or it isn't.
It's hearsay before the court lets it in, right?
If it is in fact hearsay, but if substantively,
And I'm not talking about hearsay within the business record. That's not what I'm talking about. I'm talking about laying the proper foundation for the trial court to let it into evidence. Once it's in evidence, then it's an exception to the hearsay rule.
yes, correct. Once it's in evidence that it would come in under an exception to the hearsay rule. This one did in fact come under the business record exception. And then I believe the
But that's what Judge Bagley ruled, right?
Judge Bagley ruled that correct. And it seems to be an issue of whether the documents were prepared at or near the time of the event recorded. And there was testimony subsequently showing that that was in fact the case for this document, because there was testimony from Mr. Gonzalez where he seemed to be saying it was handwritten as the cargo was loaded on the boat. There was testimony on his cross-examination that it was the only document he was able to save from the vessel, and we know the vessel was arrested shortly after this all happened, so logically it could have only been at or near the time of the event. And I believe that is important because a lot of the case law reversing for hearsay exception, I know there's a 4th TCA Clark-Well, they only reversed because there was incontrovertible evidence that the document was in fact hearsay. Here, I believe there's evidence where there's reasonable inferences to be made that it falls within the business record exception and actually does meet this requirement that the document be prepared at or near the time of the event. And in the face of a non-specific hearsay objection, I believe it's a harsh result to require anything more of the circuit court. And there's also a harmless error argument that was advanced in our answer brief that even if this wasn't a business record, it seems to be a past recollection recorded. So it alternatively could have been used on that ground. And I noticed in our case on preservation, the Carter v. State case from the 4th DCA saying holding hearsay is sufficient, they didn't just exclude it, they also considered alternative grounds of admissibility that weren't necessarily considered by the trial court. So I believe you can consider this where I believe the evidence does show that this would have been a past recollection recorded from Mr. Gonzalez, who is the principal of this business. And then as for the issue of damages, I don't know if I understood counsel's argument correctly that this hinges on the admissibility of the handwritten notes, but and that was dealt with previously, but regardless of that, we have the jury instruction was agreed to on the standard for what evidence is needed to support damages. We have Mr. Gonzalez testifying to the $288,000 damage figure without objection that he's speculating. So I believe it is a jury instruction, and if I had to guess, that's probably a pattern jury instruction. That tells me that the jury gets some say in the damage to be awarded in resolving the conflicts. And I believe the case law says there's no need to be exact. You just need to be reasonably certain about your damages, and I believe that standard is met here. So for those reasons, I believe the jury's verdict should be affirmed.
Thank you very much.
Thank you.
Couple minutes,
Briefly, just Salter, to your point, the tow date of the vessel is the most important term for this agreement. They specifically alleged in their complaint that the agreement was for the 23rd, and they had the burden to present evidence of a conversation that occurred between two parties in order to form this agreement. That is completely lacking from the plaintiff's case. And the reason why it's lacking, and I go back to Dubin, the reason why that conversation isn't there, the reason why Mr. Gonzalez says, I called them, I told them to tow the boat on the 23rd, they agreed. The reason why that's not there is because Dubin was in charge of that. He admitted that. So there's nowhere in this record where Gonzalez testified conclusively or even giving all inferences in favor of the plaintiff. There's no evidence that this court, that the appellee can point this court to show that the contract was, in fact, for the 23rd. The contract was for the 24th, and unfortunately the boat was seized, and the trip could not happen. Regarding your point, Judge Fernandez, about the hearsay, you're absolutely right that the Carter case holds that the hearsay objection is enough. The record was hearsay, and it was admitted without meeting the strict foundational requirements of the business record exception. If you look, Your Honor, to the Sanchez case reversed specifically because no questions were asked. When was this document made at or near the time of the event? None of that testimony can be found in the trial transcript. What appellee points you to is so there's handwritten notes, and then there's notes, and then there's a page of typed notes. There's notes within these notes. We don't know whether these notes were prepared when the cargo was coming in, and then there was other notes added. We don't know when this document was typed up in the computer and then other markings made. We just don't know because the questions weren't asked, and therefore the document was improperly admitted.
Let me ask you a question. Sanchez case is out of the 4th DCA. Do you have any cases supporting your position out of the 3rd? Everybody's been talking about the 4th. In my recollection of the cases coming out of the 3rd is the foundation has to be specific, the objection has to be specific. So I'm wondering, did you come across any cases that followed what the 4th said?
Your Honor, I believe I don't have a specific case from the 3rd, but what cases from the 3rd do hold is that when they refer to a specific objection, they mean here's objection, Your Honor, hearsay.
I don't know if I agree with you on that, but I appreciate you saying that you could find anything, because I couldn't either. So, very good. Thank you very much, counsel. In conclusion, you would ask.
In conclusion, I would ask that the judgment against Hempstead Marine be reversed, against our Hempstead Marine be reversed and entered in favor of Hempstead Marine, and a remitter be entered in favor, and a remitter judgment entered in the amount of $15,000.
Thank you, counsel. Thank you both very much. Appreciate it.
Thank you.